Hello and welcome to chapter 17. In this chapter, we are going to discuss the notion of adjudication as a dispute settlement mechanism in international law. So, if you remember from the foregoing chapters, we talked about different mechanisms or ways of dispute settlement, peaceful dispute settlement in international law. Before we talked about diplomatic means of dispute settlement, including negotiation, reconciliation, and mediation. And the common characteristic of these diplomatic or non-adjudicational dispute settlement mechanisms is that they are non-binding, they are non-principled in the sense that they are not necessarily based on a certain set of international legal rules, and also the degree and extent or the depth of third-party involvement is pretty low. So normally, if negotiation, reconciliation, or mediation don't work out, states move on to next stages of dispute settlement, which is called adjudication. Now, adjudication has two different components. It could be done through arbitration and international tribunals or through litigation and international courts. Now, advantages of adjudication are that it is impartial, it is impersonal because there are third parties involved, and it is principled in the sense that it is based on certain established, customary, or treaty, rules and norms. On the other hand, adjudications come with certain disadvantages. For example, it's costly, it takes away control from the parties to the dispute. They are normally very time consuming and they just tend to get protracted. They have issue area limitations because the normally jurisdiction needs to be circumscribed to a very precise issue area. Also, adjudication normally takes away imaginative, creative, outside the box solutions. Adjudication also has the disadvantage of creating winner-loser dichotomies. And some people have argued that there is Western bias towards adversarial methods are present in adjudication, and this is contrasted to non-adversarial, non-Western methods that don't create these winner-loser dichotomies and the adversities that that come out of them. So, but remember before moving forward that arbitration differs from former settlement by permanent courts, also known as litigation, in that arbitration or arbitral panels are ad hoc. They are normally constituted for each specific dispute through an agreement that is usually called a compromise. In arbitration, states have a choice in designating panel members, and they can specify the scope of jurisdiction and the body of law that would apply. So international adjudication, with that caveat about arbitration in mind, is based on formal state consent. This is sometimes called express grant. Adjudication needs treaty law or other form of agreement for submission to adjudication and judicial determination. But also remember that there is no compulsory rule of international law to mandate adjudication. And remember that adjudication is not final and it could be appealed. There are a couple of mechanisms, well-known bodies for adjudication. For example, we have the Permanent Court of International Justice, the PCIJ, which was later on replaced by the International Court of Justice, the ICJ. You also have the International Criminal Court, ICC. You also have mechanisms for adjudication within certain international conventions or organizations. For example, you have the uh, UNCLOS 3 having its own adjudication mechanism, or the World Trade Organization is one of the more well-known organization that has its own dispute settlement slash adjudication mechanisms. But on the question of international arbitration, this is a rough trajectory of its evolution. It starts with the Alabama claims of 1872, which we have covered before. The Alabama claims establishes the principle of international arbitration, essentially, and is one of the first movements to codify public international law for finding peaceful solutions to international disputes. And then the Alabama claims achievements are furthered through the Hague Peace Conference of 1899, which establishes the Permanent Court of Arbitration. But like I said before, arbitration has this this characteristic that it is normally ad hoc, meaning that these arbitral mechanisms are not permanent. They're also issue area specific. For example, the Rainbow Warrior case that we've covered before, and they're based on the notion of these agreements that are called a compromise, which determine the scope, panel member configuration, and procedures, and those types of procedural slash logistical contours of arbitration. You also have one of the more well-known arbitration mechanisms are the so-called mixed claims commissions. Some of the more well-known examples of mixed claims commissions are the Iran-U.S. Claims Tribunal, the Mexican-American Mixed Claims Commission. And mixed claims commissions and their establishment actually goes back to the Jay Treaty of 1794 between the United States and Great Britain. These are, like I said, these are ad hoc arbitral bodies that are founded on the basis of international agreements, the so-called compromises. And they normally consist of a majority of nationals of the state parties to the agreements and are established with the purpose of settling claims which have arisen before citizens of one state and the other state. So escalating from arbitration, you have the notion of judicial settlements, sometimes through litigation. So if diplomacy and those other diplomatic means of settling disputes don't work and arbitration is not an option, as kind of a last resort to peacefully settle disputes, states could resort to judicial settlements. And some of the more well-known judicial settlement bodies are the Permanent Court of International Justice, which was in operation between 1922 and 1946, essentially during the interim between World War I and World War II. Then later on, the PCIJ was replaced by the ICJ, the International Court of Justice, in 1946. You also had the Rome Statute and the establishment of the International Criminal Court in 2002. You also have some other judicial settlement mechanisms like the ICTY, which we talked about before, the International Criminal Tribunal for the former Yugoslavia, or the ICTR, the International Criminal Tribunal for Rwanda, or the European Court of Human Rights, or the International Court of Arbitration that was established in 1923 and is headquartered in The Hague. So we're just going to talk about the PCIJ and the ICJ as really the two more well-known judicial settlement mechanisms in international law. The PCIJ, the Permanent Court of International Justice, was the first permanent international tribunal with general jurisdiction. And between 1922 and 1940, the PCIJ essentially deals with or settles 29 contentious cases between states and delivers 27 advisory opinions. But remember that unlike the International Court of Justice, the protocol or the option clause of the League of Nations accepting PCIJ's jurisdiction was separately ratified. So by joining the League of Nations and by ratifying the Covenant of the League of Nations, it did not make you automatically a member of the Permanent Court of International Justice. So there was a separate optional clause of the League of Nations that was required to join the PCIJ. So sources of the PCIJ's compulsory jurisdiction were, the optional clause of the League of Nations, or the General International Conventions and special bipartite international treaties. But then the PCIJ was replaced by the ICJ with the establishment and with the founding of the United Nations Organization. The ICJ has global jurisdiction. It is a court of original jurisdiction, meaning that the cases that come before the International Court of Justice have not been adjudicated before. That's the meaning of original jurisdiction. Also, the ICJ is a court of last resort, so to speak, which means countries only come to the ICJ when they have no possible way of resolving the conflict themselves. Another feature of the ICJ is that it has no criminal jurisdiction, meaning that the International Court of Justice has no jurisdiction to try individuals accused of war crimes or crimes against humanity, which was one of the main limitations and shortcomings of the ICJ. And the reason for lack of criminal jurisdiction is that the ICJ is not a criminal court and it does not have a prosecutor to initiate those criminal proceedings. Also remember that the ICJ only recognizes and exclusively recognizes state litigants. So only states could file a claim with the International Court of Justice. The International Court of Justice is composed of 15 judges that are elected to staggered 9-year terms by the UN Security Council and the UN General Assembly. And membership in the court is supposed to be well balanced to represent the main forms of civilization and of the principal legal systems of the world. And these would be, the civil law systems, the common law systems, and the socialist law systems. So on ICJ's jurisdiction, or issue of its competence, there are a couple of points that we need to keep in mind. Number one is that contentious issues between states in which the court produces binding rulings between states that agree or have previously agreed to submit to the ruling of the court. In other words, jurisdiction is founded on special agreements, or like I said before, these are called normally compromises, or optional clause declarations. Number two is that International Court of Justice sometimes issues these non-binding advisory opinions, which essentially give reasoning, give explanation, justification, give informed opinion on certain critical issues, and these advisory opinion requests are normally made by international organizations like UN General Assembly, by World Health Organization, and so forth. One of the most well-known advisory opinions of the ICJ was on the use of nuclear weapons. And as we've covered before, the ICJ only has jurisdiction on the basis of consent of state parties. And as I said, only states could be parties in cases that come before the ICJ, and not individuals. Sometimes international organizations could also be parties in cases that come before the ICJ, but not individuals. So here you have Article 36 of the ICJ statute. I'm not going to read the entire thing, but I just put this here so you could just look it over and get an idea as to the functionality, the scope of jurisdiction of the ICJ. And Article 36 essentially claims and reads that the jurisdiction of the court comprises all cases which the parties refer to it, and all matters specially provided for in the Charter of the United Nations or in the treaties and conventions in force. The state parties to the present statute, the ICJ statute, may at any time declare that they recognize as compulsory ipso facto and without special agreement in relation to any other state accepting the same obligation, the jurisdiction of the court in all legal disputes concerning, a treaty, a question of international law, and other things. So, number 3 says that the declarations referred to above may be made unconditionally or on condition of reciprocity on the part of several or certain states or for a certain time. And this clause is important because, as we're going to talk about before when we talk about the colony reservation, sometimes states argue that they would only accept compulsory the compulsory competence and jurisdiction of the ICJ based on reciprocity and not unilaterally. So we'll talk about it later. Next slide deals with the relationship between the ICJ and the UN Security Council, and the issue of compliance and enforcement mechanisms if non-compliance occurs. So essentially, by signing the UN Charter, a state member of the United Nations undertakes to comply with any decision of the court in a case to which it is a party. Obviously, this happens with the prior consent of the state party. So since a case can only be submitted to the court and decided by if the parties have in one way or another consented to its jurisdiction over the case, it is rare for a decision not to be implemented. But a state which contends that the other side has failed to perform the obligations incumbent upon it under a judgment rendered by the court may lay the matter before the Security Council, which is empowered to recommend or decide upon the measures to be taken to give effect, essentially to enforce the judgment. And one of the more interesting cases of this is the complications when the country who is in breach or who refuses to comply by the ruling of the ICJ happens to be a permanent member of the UN Security Council, which enjoys the so-called veto power. And the Nicaragua case we'll talk about later is one of these interesting cases. But anyways, the UN Security Council, in this case, requests an advisory opinion on one occasion on July 1970 regarding the legal consequences of South Africa's continued presence in Namibia. On July 21st, 1971, the ICJ issues its advisory opinion concluding that South Africa was under an obligation to withdraw from Namibia and that UN member states were obligated to recognize the illegality of South Africa's presence. The Council, meaning the UN Security Council, took notice with appreciation of the opinion and agreed with the ICJ's legal findings in Resolution 301 of 1971. So the relationship between the United States and the ICJ is very interesting, as has gone through its own ebbs and flows. Like I said, one of the more contentious episodes in the United States relationship with the ICJ was this case that came before the ICJ in 1984, Nicaragua versus the United States. And the case concerned the military and paramilitary activities by the United States against Nicaragua, which included the mining of Nicaragua's harbors. So in this case, on the issue of jurisdiction, the United States, despite its objections, was subject to the court's jurisdiction on the basis of either Article 36, which establishes compulsory jurisdiction, or the 1956 Treaty of Friendship, Commerce, and Navigation between the United States and Nicaragua. And the ICJ verdict was that the United States, in breach of its obligations under customary international law not to use force against another state, not to interfere or intervene in its affairs, not to violate its sovereignty, not to interrupt peaceful maritime commerce, and in breach of its obligations under Article 19 of the Treaty of Friendship, Commerce, and Navigation between the parties signed at Managua on January 21st, 1956. And in the aftermath of this ruling by the ICJ, the United States withdrew its consent to the court's compulsory jurisdiction and ended its previous 40-year legal commitment. And another interesting note about the relation between the United States and the ICJ is the so-called Connolly Amendment, which was proposed by Senator Tom Connolly of uh, of Texas regarding the compulsory jurisdiction and the scope of compulsory jurisdiction of the ICJ. So essentially, through the Connolly Reservation, the United States qualified its acceptance of the compulsory jurisdiction of the ICJ under Article 36 of the ICJ statute. And this happened through a clause that excludes disputes with regard to matters which are essentially within the domestic jurisdiction of the United States as determined by the U.S. So this was the crux of the Colony Reservation that allowed states to avoid ICJ compulsory jurisdiction previously accepted under the optional clause if they decide not to respond to a particular suit. And this, whether to accept this compulsory jurisdiction or not was purely at the discretion of the United States according to the Connolly Amendment. And this is normally exercised when a state determines that a particular dispute is of domestic rather than international character, and naturally, based on that determination, domestic jurisdiction applies. So if a state invokes the self-judging reservation, the Connolly Reservation, another state may also invoke this reservation against a state, and thus a suit against that second state would be dismissed. So that's a tricky part about the Connolly Reservation, because acceptance of compulsory jurisdiction according to the ICJ statute is based on reciprocity. All right, two well-known, kind of potentially watershed really cases dealing with the ICJ and the United States that you need to know for this chapter. Number one is the Avena case of 2004 that deals with and concerns the arresting, detaining, trying, convicting, and sentencing of 54 Mexican nationals to death row without allowing Mexico its international legal obligations in accordance with Article 5 and 36 of the Vienna Convention on Consular Relations. So the ICJ verdict here was that the United States was in breach of its obligations under the Vienna Convention on Consular Relations in not allowing representation from Mexico to meet with Mexican citizens arrested and imprisoned for crimes committed in the United States. Another relevant case was the Lil Garcia versus Texas in 2011, where the Supreme Court in the United States denied Lil Garcia's application for stay of execution and application for writ of habeas corpus. And the reasoning for denying the stay of execution and application for writ of habeas corpus was that the U.S. Congress had not enacted the implementation legislation. And the legacy was the legacy of the Lil Garcia case was that without authority from the Congress or Constitution, the President of the United States lacks the authority to enforce international treaties or decisions of the International Court of Justice.